Without objection, the chair is authorized to declare a recess at any time. Without objection, members of the full committee not on this task force are authorized to participate in today's hearing. As a reminder, I ask all members to keep themselves muted when they are not being recognized. The staff have been instructed not to mute members, except where a member is not being recognized and there is an inadvertent background noise. Members are also reminded that they may only participate in one remote proceeding at a time. If you're participating today, please keep your camera on. And if you choose to attend a different remote proceeding, please turn your camera off. This hearing is entitled Preserving the Right of Consumers to Access Personal Financial Data. And I will now recognize myself for 4 minutes to give an opening statement. Good morning, and welcome to this hearing of the Financial Services Committee FinTech Task Force. Today's hearing will discuss various issues surrounding the gathering, usage, and protection of consumer financial data. I'd like to begin by thanking our distinguished panel of witnesses who have agreed to testify and offer their diverse perspectives as Congress and regulators grapple with this rapidly changing landscape in this area. The collection and utilization of consumer financial data has exploded in the past decade as the usage of smartphones, myriad devices, and the Internet of Things, enhanced computational power and algorithms with artificial intelligence and robotic process automation having combined to transform the way consumers manage their finances and conduct the most basic economic activities, while also changing the way financial services providers have responded to consumers' desires and preferences. Whether using a payment processor to split a dinner bill, or employing a personal financial management app to track spending, or accessing a mobile lending platform for a personal loan, consumers and financial service providers rely more keenly on the data flow that underpins the delivery of those services. The consumer financial data ecosystem has also expanded beyond traditional banks and insurers to include data aggregators, payment processors, neobanks, and mobile lenders employing technologies that were not necessarily anticipated in earlier legislation and regulation. While there is little doubt that recent emerging financial services innovations have the real potential to improve the efficiency and accuracy of those services while reducing costs and fostering greater inclusion, the relentless full-spectrum cultivation of consumer data and the manipulation of that data raise important policy questions about personal data protections, user control, and meaningful consent to sharing that data, as well as the ultimate contours of personal privacy. In fairness, many financial services providers, both traditional and fintechs, have requested regulatory guidance and greater clarity in this area. While some current laws governing financial data, Gramm-Leach-Bliley, Dodd-Frank, the Fair Credit Reporting Act, and the Equal Credit Opportunity Act are generally instructive, there are serious gaps that leave much uncertainty given the transformational technology and advancements as well as changing relationships and customer preferences that we face today. Again, I want to thank our witnesses for your willingness to help this task force with its work. I look forward to our discussion, and the chair now recognizes our ranking member, the gentleman from Ohio, Mr. Davidson, for 5 minutes for an opening statement.
Thank you, Chairman Lynch. I truly appreciate that you're conducting this hearing today on a very important and prevalent issue. Financial technology seems to be developing at light speed in recent years, so it's encouraging to see this task force and the committee keep up with the industry, or attempt to. Like I said 2 years ago when this task force held a similar hearing on personal financial data, it's great that there's common ground across the aisle on this topic. I think we all agree on the importance of protecting consumers' control over their own financial data. But does this mean that we both, regulators and policymakers alike, are moving fast enough to address the uncertainties in this area? I'm not convinced that we are. However, it is encouraging to see the CFPB continuing to make progress towards rulemaking under Section 1033 of the Dodd-Frank Act. Section 1033 provides the opportunity to strengthen consumer control over their personal data. When a consumer grants consent for any party to access or hold their personal financial data, it's vital that this consent is read narrowly. I'm optimistic that the CFPB can adequately define the proper scope of that consent, whether this involves limiting the specific financial activity for which the data is needed or the length of time it is authorized. I expect these types of questions to be at the forefront of the CFPB's process as they undertake the rulemaking. Ideally, they will conclude, as I have, that individuals have a property right in their own data, much like a songwriter would have protection for their lyrics or music as composed. Individuals own the data that they create. As things currently stand, I believe that consumers do not fully appreciate that what they're consenting to whenever we utilize third-party financial service providers. Please note this is not meant as a swipe at fintech. Applying for personal loans, conducting peer-to-peer payments, getting mortgages, receiving financial product recommendations, just to name a few examples, have never been easier. Fintech companies have made financial services more accommodative than ever before. Despite this financial revolution, we need better transparency regarding the relationships between financial institutions, third-party service providers, and the consumers who are providing the data. It's encouraging to see some progress within the industry to shift away from practices such as screen scraping, which essentially circumvents any need for consent between a financial service provider and a third party, and towards application program interfaces. However, I believe policymakers and regulators retain the authority to properly shape these relationships and protect consumers' financial privacy moving forward. I'm not going to say that regulators need to impose regulations with technical guidance. It's best to leave those details to industry. However, regulators can still provide consumer-focused, principle-based framework that will allow for innovation and competition. I would be remiss if I didn't acknowledge that we have some industry-specific standards in place to address consumer privacy data. These policies can largely be found within Graham-Leach-Bliley Act, the Fair Credit Reporting Act, the Electronic Fund Transfer Act. And while Section 1033 of Dodd-Frank is a step in the right direction, we are left with a fragmented regulatory framework when it comes to consumer privacy data protection. I know this hearing is more narrowly focused on the 1033 rulemaking and open banking, but I think it's important that Congress continues to hold the broader conversation as well. We are in the process of developing a bill that will be titled It's Your Data, which hopes to secure that property right in law for American citizens. While we can all agree on the general outcome, reaching that outcome is a complicated endeavor through Congress. I'm certain many questions here today will be rather specific and potentially complex. Consumer data has become so leveraged and holds so much value that it has ultimately become a very large business asset. No matter how big the financial industry gets or how much financial technology evolves, the monetary value of consumer data will never be worth more than the fundamental right to privacy. Our Constitution is supposed to protect the right to privacy for every American citizen, and it's our duty to do that. I very much look forward to hearing our witnesses' testimony today, and I yield back.
The gentleman yields back. Today, we're pleased to welcome the testimony of our distinguished witnesses. First, we have Mr. Tom Carpenter, the Director of Public Affairs with the Financial Data Exchange. Next, we have Mr. Raúl Carrillo, an Associate Research Scholar at Yale Law School and the Deputy Director of the Law and Political Economy Project. Next, we have Ms. Kelly Thompson Cochran, the Deputy Director of FinRegLab. Next, we have Ms. Chi-Chi Wu, a staff attorney with the National Consumer Law Center. And lastly, we have Mr. Steve Smith, who is the CEO and co-founder of Finicity. Witnesses are reminded that their oral testimony will be limited to 5 minutes. You should be able to see a timer on your screen that will indicate how much time you have left, and a chime will go off at the end of your time. I would ask that you be mindful of the timer and quickly wrap up your testimony if you hear the chime, so that we can be respectful of both the witnesses and the committee members' time. Without objection, your written statements will be made part of the record. Mr. Carpenter, you are now recognized for a 5-minute summation of your written testimony. Thank you.
Thank you. Chairman Lynch, Ranking Member Davidson, and members of the Task Force on Financial Technology, thank you for the opportunity to testify at today's hearing. My name is Tom Carpenter, and I serve as Director of Public Affairs at the Financial Data Exchange, or FDX. I must begin by saying that FDX is currently barred from taking positions on most legislative or regulatory policy issues. FDX does advocate for market-led API standards for data sharing, but please consider the rest of my comments today as educational and intended to inform the task force about FDX and the way that our work interacts with policy and legislation. The best analog to understand FDX is the Bluetooth standard. As consumers now know today, Bluetooth brought together many different consumer electronics manufacturers to create a standard specification so consumers could use differently branded products in an interoperable manner. In the same way, FDX brings together diverse financial industry players under a common application programming interface, or API standard. This allows consumers to share and move financial data between financial institutions, fintechs, and intermediaries in a secure and transparent manner, and one which is not dependent on where one banks or which fintech app a consumer may choose to use. And most importantly, adoption of the FDX API is replacing the need for data sharing that relies on shared consumer login credentials and screen scraping. A few additional details about FDX. FDX is a nonprofit body. The FDX API is also royalty-free. FDX currently has 200 members across the financial sector globally, including fintechs, banks, data aggregators, consumer groups, payment networks, financial industry groups, and other stakeholders. And I'm pleased to be joined in this hearing at the witness table by Chi-Chi Wu and Steve Smith, who both represent FDX member organizations. And in case you thought FDX was just an interesting concept, I'm pleased to tell you that 22 million consumer accounts have been transitioned from screen scraping to the FDX API so far. That's 22 million consumer accounts. As this task force is aware, fintech innovations are allowing consumers to use their own financial data to lower costs via more efficient processes, better rates, and lower fees, expanding credit access to thin file or no file borrowers when a traditional credit score is limited or incomplete, and to empower better decision-making via a consumer's own big data, just like large companies have done for years, so they can actually see all of their accounts in one place. With this in mind, here are a few key points I would like to make the task force aware of today. First, it's critical for the task force and regulators to draw a bright line distinction between user permission financial data sharing versus data brokerage or data harvesting. Consumer permission data sharing using the FDX API is fully controlled by the consumer and must include explicit consumer consent. Data brokers or harvesters instead collect and sell data about consumers, often without express consumer consent, control, or awareness. Secondly, FDX is committed to and believes that 5 core principles must be present in any system of financial data sharing or open banking to ensure the industry serves the needs of consumers. These principles are control, access, transparency, traceability, and security. I expand upon these in my written testimony, and I'm happy to take questions on them. Third, FDX believes that technical API standards are best left to the financial industry rather than defined by regulators. For a host of reasons, and again expanded upon in my written testimony, we believe the industry is best suited to maintain and continually adapt standards to the needs of the market and consumer demand. As for potential CFPB rulemaking, FDX submitted comments to the CFPB's ANPR earlier this year, and FDX was actually mentioned or referenced in almost half of the comments the CFPB received. As above, our comments stress to CFPB the importance of FDX's 5 principles, as well as our core belief that technical data sharing standards should be left to the industry. FDX also believes potential CFPB rulemaking would need to find a good balance. Consumers must be able to access and share the full extent of their own financial data with third parties via APIs in the same way they can today via screen scraping, including some third parties who may have no relationship with a consumer's data provider. At the same time, data providers like banks must be able to maintain sound risk management practices and activities consistent with applicable laws and regulations. FDX is hopeful that its own certification of FDX API implementations will be helpful here. Finally, FDX encouraged the CFPB to do more to prioritize the adoption of market-led API standards and to reference or acknowledge these standards to further amplify the work, and also to harmonize industry standards and regulation as much as possible so that standards are not caught between competing or overlapping or disjointed requirements. Thank you again for the opportunity to testify today.
Thank you, Mr. Carpenter. Mr. Carrillo, you are now recognized for 5 minutes to give your oral presentation of your testimony. Thank you.
Thank you. Chair Lynch, Ranking Member Davidson, distinguished members of the task force, thank you for inviting me to testify this morning. I offer my testimony as an associate research scholar at Yale Law School, but I previously worked as an attorney for low-income consumers in New York City and as special counsel to the enforcement director of the CFPB. This morning, I repeat previous calls for policymakers to adopt a bright line approach to financial data regulation, recognizing both the benefits and harms of collecting highly personal information. Today, a payment made with a mobile money account typically includes a merchant, bank, payments processor, mobile device maker, internet service provider, and an app provider. Additionally, roughly 50% of US consumers and 95% of US deposit accounts are estimated to have signed up for financial apps that frequently rely on unregulated or underregulated data aggregators. All of these companies can share data widely with other corporations and law enforcement agencies. I agree with the National Consumer Law Center that consumers deserve more control over their data relative to banks and other financial institutions. That being said, consumer rights to access, review, manage, correct, and delete data can only be meaningful with a broader policy that minimizes data collection and inappropriate usage as a first-order principle. Although we should be able to entrust fintechs and aggregators to collect data on our behalf, this collection process itself must be subject to greater accountability. Section 1033 rulemaking should promote consumer control of information, but in the broader context of data minimization rather than maximization. Just as the CFPB offers more control to consumers via their agents using technologies like APIs, they must enforce federal consumer protection, including fair credit reporting laws in this space. If consumers are harmed and either banks, fintechs, or aggregators have not provided accurate records of existing financial information, and just as importantly, not included an explanation of how account data has been shared, the Bureau should take appropriate action with the presumption that noncompliance with Section 1033 rulemaking has led to unfairness to consumers and the broader purpose of Dodd-Frank with which the CFPB was entrusted has not been upheld. Beyond this, we must upgrade federal consumer data and privacy and security laws from the notice and consent paradigm. There are limits to the ways in which individual consumers can meaningfully make choices about how their personal data is used. As legal scholar Salome Viljoen argues, the very point of data production in the digital economy is to put people into population-based relations with one another and predict broader trends in social and collective behavior. Corporate and government actors frequently do not even know the purpose of collection until after they analyze an aggregated data set and identify proxies. Meaningful consent cannot exist when people do not know what information they are revealing or to what end. As a matter of public policy, then, we should not be able to forfeit our general rights to data, privacy, and security simply by clicking agree, as industry would often have us believe. Ultimately, Congress must shift the burden of data protection from consumers, courts, and litigators to regulators and tech companies. The collision of big tech and Wall Street in this space and the continuing blurring of distinctions between financial and non-financial data demand especially careful scrutiny. Legislation should limit processing to only the minimum amount of data strictly necessary to carry out an explicit, narrow purpose, such as the provision of a good or service requested by individuals in an intentional interaction. This principle itself demands a robust form of transparency that Section 1033 rulemaking can help provide. I agree with Ranking Member Davidson's earlier comment that privacy concerns should trump property concerns in this space. Privacy and security are especially important as we consider policies of financial inclusion aimed at poorer communities and communities of color. People make volunteer payments and credit data that, when aggregated, confers sensitive information about disadvantaged groups in unpredictable ways. Public benefits, family, criminal, immigration, and national security law already provide a channel for policing troubled by civil rights concerns that is further exacerbated by surveillance. Moreover, mass data collection does not solve our deeper issues of financial exclusion. Apps are solutions to certain problems, acute problems, but not structural problems. The erosion of data security and privacy law in consumer finance should encourage us to move away from over-reliance on credit as a method of social provisioning, growth, and poverty reduction, and focus on better jobs, higher incomes, and more equitable economic policies. Thank you.
Thank you, Mr. Carrillo. Ms. Cochran, you are now recognized for 5 minutes to give an oral presentation of your testimony.
Good morning. Thank you, Chairman Lynch and Ranking Member Davidson. My name is Kelly Thompson Cochran. I'm the Deputy Director of FinRegLab, an independent research organization that evaluates the use of data and technologies in creating a more responsible and inclusive financial marketplace. We have published a number of reports on
Ms. Cochran,
data.
I'm not sure if your microphone is on.
Ooh. Can you hear me?
Yes, much better. Thank you.
I'm so sorry.
That's okay. You were very clear in this room, but I think online it wasn't audible.
Okay, should I start over or, okay, thank you. Good morning and thank you again to Chairman Lynch and Ranking Member Davidson and the members of the committee. My name is Kelly Thompson Cochran. I'm the Deputy Director of FinRegLab, an independent research organization that evaluates the use of data and technology to create a more responsible and inclusive financial marketplace. We've published a number of reports on customer data access issues, including a groundbreaking empirical evaluation of the use of cash flow data for underwriting small business and consumer credit. Our research finds that the system for consumer-directed transfers is benefiting many consumers and small businesses today, but it is also creating risks and burdens that reduce its ability to create greater customer-friendly innovation and competition. Efforts to meet the financial services needs of underserved populations may be particularly sensitive to these risks and burdens. For instance, where providers' margins are already thin, where particular populations are particularly sensitive to concerns about privacy and data security. Thus, improving the market and regulatory infrastructure for customer-directed transfers has critical implications for competition, customer protection, and financial inclusion going forward. We are encouraged to see several federal regulators beginning initiatives to address critical threshold issues. While additional work by industry and Congress will be needed to improve the broader data ecosystem, the regulatory initiatives are critical to help sharpen the focus of these complementary efforts. The market today is moving towards safer and more efficient technologies for data transfers, both through bilateral agreements between large players and through broader standardization initiatives. But progress has been slowed by competitive tensions, coordination challenges, and regulatory uncertainty. While industry-led standardization efforts can be highly beneficial, particularly on technical issues that are hard to enshrine in regulation, historical experience suggests that such efforts will be far more efficient and effective if regulators set certain basic parameters. 3 such initiatives are currently underway. In addition to the Bureau's 1033 rulemaking, which we've already discussed, the Federal Trade Commission is modernizing information security standards for non-bank financial service providers under the Gramm-Leach-Bliley Act, and prudential regulators are harmonizing third-party service provider guidance as it applies to customer permission data transfers. We believe that the industry efforts will be substantially strengthened if the regulators address 5 key sets of issues in their proceedings. The first is the deadline for particular groups of financial service providers to make data available upon consumer request under 1033. The second is the scope of the data that is subject to 1033 data access rights, the application of exceptions to that statute, and whether financial data sources can impose additional conditions on data transfers. Third, the obligations of companies that are acting on behalf of the consumer in connection with a 1033 data transfer, and the requirements for data recipients to safeguard that information. Fourth, the Bureau's plans to begin supervision of data aggregators and other non-bank financial service providers that compile large amounts of customer permission data. And fifth, the scope of banks' oversight responsibilities concerning aggregators or aggregators' customers in their downstream handling of customer data. Interagency coordination is critical between these various initiatives because they are deeply interconnected. For instance, CFPB supervision of aggregators could reduce third-party risk to banks. And third-party service provider guidance can affect the technical infrastructure and processes for 1033 data transfers. These regulatory initiatives will also help to pinpoint the need for specific congressional actions. For instance, 1033 does not affirmatively define protections for data transferred under its provisions, and while other federal laws potentially provide safeguards, they were not crafted specifically for this transfer system and may not apply to all of its use cases. More broadly, as others have discussed, there are other gaps showing up in the financial regulatory ecosystem as players and data practices and technologies change. Our written testimony discusses this in more depth, things like meaningful consumer permission, while also dealing with the fact that there's evidence of customer overload, information overload, and trying to manage all of the permissions that they are faced with. The CFPB and other federal agencies will likely grapple with many of these cross-cutting issues in the course of these proceedings, but Congress has a critical role to play in creating consistency across statutes. Modernizing customer data protections would help to reduce risk to consumers and small businesses, create a more level playing field among financial services providers, and encourage greater innovation and competition going forward. Thank you again for the opportunity to speak today.
Thank you very much. Ms. Wu, you are now recognized for 5 minutes to offer an oral presentation of your testimony. Welcome.
Thank you, Mr. Chairman. Thanks to Ranking Member Davidson, members of the subcommittee, for the opportunity to testify. I'm testifying on behalf of the low-income clients of the National Consumer Law Center. So the topic of the hearing is preserving the right of consumers to access personal financial data. And I absolutely agree. We support the President's executive order on competition and its call for the CFPB to continue the Section 1033 rulemaking. Access to personal financial data, in particular bank account transaction data, has a lot of potential to benefit consumers. In particular, it could benefit the 45 million credit invisible consumers who lack a credit history or have files so skimpy that a credit score can't be generated. But any access to personal financial data must be subject to what I call the 3 C's and 1 D. Consumer choice and control, competition, consumer protection, and the D is data security. Think about the data that's being accessed, how sensitive and revealing it is. Think about your own bank statements or credit card statements. And remember, a lot of credit invisible consumers won't have a credit card, so they'll be using their debit card a lot. Bank account transaction data might show when the consumer gets paid, where they shop, what advocacy organizations they support, or which healthcare providers they use. So consumers need control. Consumers are tired of not having control over our own personal data. We are tired of tech giants silently collecting data about us to show creepy personalized ads. And the original privacy invading tech giants are the big 3 credit bureaus, Experian, Equifax, and TransUnion, who started collecting our information and monetizing it over 50 years ago without our permission. We need a better system with strong provisions for consumer control, not just whether to consent to sharing, but for what purposes, for how long, and control over exactly what data elements get shared. And no mice type click wrap pro forma consent. It must be real, meaningful, informed, and knowing. Dashboards, such as the ones developed by FDX, are a good start. What's not good are efforts to access bank account data without consumer control, which unfortunately we're starting to see, including a current pilot for this company called Early Warning Services to supply bank account information without consumer consent. Competition. After the Equifax data breach, there was a lot of discussion about how consumers have no control over credit bureaus because we're not the customers, we're the commodity. And it's true. The credit reporting system is an oligopoly, really a functional monopoly where we can't choose between the big 3 or walk away. Data aggregators and financial account data could serve as potential competition to the credit bureaus. and it could be more accurately precisely because of consumer control. If an aggregator does a terrible job with the accuracy of data, consumers should have the ability to revoke consent and delete their data from the aggregator's database. Of course, one risk we're already beginning to see is that the big three have started purchasing alternative data providers. For example, all three have bought consumer reporting agencies specializing in subprime credit. We'd be really worried if the big three started buying up data aggregators as well. Consumer protection. New entrants to a market love to claim they're the best thing since sliced bread, and existing regulation doesn't apply to them because they're so innovative or novel, but not so much. Even though they were drafted several decades ago, the federal consumer laws were written pretty broadly. So if it's used for credit underwriting, the Fair Credit Reporting Act applies and the Equal Credit Opportunity Act is implicated. And since deposit accounts are involved, the Electronic Funds Transfer Act is implicated. I very much appreciate that my fellow witness, Finicity, has taken a similar position with respect to the Fair Credit Reporting Act. In addition, we've urged as part of the Section 1033 rulemaking that the CFPB should establish supervision authority over larger participant data aggregators. Data security. Speaking of supervision, we need supervision for data security. Since the Equifax data breach in 2017, we've urged Congress to transfer the Data Security Authority in Gramm-Leach-Bliley to the CFPB for credit bureaus, and we'd urge the same with respect to data aggregators. At a minimum, the FTC should complete its rulemaking to strengthen the safeguards rule under that act. Financial account information holds great promise, but also great risk. It could open doors to credit for millions of underserved Americans, but the nightmare scenario is a system where every consumer, thick or thin file, high FICO score or not, is forced to give up their privacy and allow each creditor, employer, insurer, landlord, and government agency a direct and permanent digital pipeline to their bank account data. It's up to the regulators and ultimately Congress to make sure that this data promotes consumer welfare without hurting our interests. Thank you for the opportunity to testify and look forward to your questions.
Thank you, Ms. Wu. Mr. Smith, you're now welcome to offer a 5-minute summation of your written testimony. Thank you.
Thank you. I'd like to thank Chairwoman Waters, Ranking Member McHenry, Chairman Lynch, Ranking Member Davidson, and the FinTech Task Force for the opportunity to speak with all of you today. My name is Steve Smith, the co-founder and CEO of Finicity, a MasterCard company. Finicity allows financial account holders, typically consumers and small and mid-sized businesses, to easily connect their accounts to a wide range of financial apps and services. This is often called data aggregation. I've spent the past 30 years working in the technology industry. In that time, there's been a remarkable technological innovation. From the internet to mobility to cloud computing, we've experienced massive advancements impacting virtually every industry. One notable technology disruption has been the use of data and analytics. Large enterprises have leveraged powerful data and analytics tools to gain insights on business operations, improve efficiency, enhance consumer experiences, and much more. All of this has enabled significant cost reductions combined with enhanced revenue opportunities. For too long, we as individuals, families, and small and mid-sized businesses have not reaped the same benefits of using our data. Why? The technology has been too expensive, or the ability to collect and analyze our data has been exceptionally difficult or cumbersome. This is where the advent of open banking or open finance powered by data aggregation is flipping the data experience to one that empowers consumers and small and mid-sized businesses with access, control, and the consented use of their data. Open banking is enabling a wide range of financial products and services that are transforming how consumers manage their money, prepare their taxes, apply for loans, make real-time payments, and better understand and improve their credit. All of this is leading to more consumer choice and better experiences, along with increased financial literacy, financial inclusion, and improved financial fitness. Finicity has been at the center of many of these empowering experiences. For example, we've enabled consumers to contribute more data to their credit scores through Experian Boost and through the Ultra FICO score. These solutions use cash flow data explicitly permissioned by users to help them build or improve credit and achieve their financial goals. So with all of this positive movement, why am I here? This is a technological shift that is still very much in the early innings. As it emerges and matures, federal policymakers will play a meaningful role in the direction and pace of this transformation by providing clarity on data protection expectations, data privacy requirements, and consumer data rights. Clearly, consumer data protection is a must throughout the data access and sharing process. Safeguarding the data is foundational to accelerating innovation while protecting the consumers from data theft. Equally, I believe we all agree that the privacy of personally identifiable information is important to further consumer empowerment. In many respects, data privacy is about consent. With clear and explicit consent, consumers will know where, how, and for what purpose their data is being used. Putting them in control enhances privacy. Data should not be shared across or among organizations without direct and transparent consent. Finally, I think most importantly, consumer data rights must start and end with an individual's ability to access, use, and benefit from their data. This is foundational to open banking. It is essential that consumers have reasonable access to all of their financial data in possession of the data holders in a format that they can permission for use to financial services and app providers of their choosing. It is critical to safeguard data rights. Otherwise, the great progress we have made so far will fade. Data rights, privacy, and protection are inextricably connected privacy policy goals, each deserving focus and critical thinking. Trade-offs may have to be made to balance competing objectives. Even adopting newer and better technologies can have unintended consequences by curtailing data access. We should bear in mind that these three goals are not equal. The consumer's right to their data must always be prioritized and maintained. We need a clear regulatory framework to protect and continue open banking in the U.S. That is why we're encouraged by the CFPB finally moving forward on a rulemaking under Section 1033 of the Dodd-Frank Act. When we started Finicity, we started with one simple thought. Data is the heart of good decision-making. It is incumbent upon all involved in this data-sharing ecosystem that consumers and small and mid-sized businesses are empowered with the data they need to make the best decisions for themselves, their families, and their organizations. Thank you again for the opportunity to address the task force and answer any question you have.
Thank you, Mr. Smith. I now will yield 5 minutes to myself for questions. Let me ask the entire panel this, although I'll select individuals at various times. The GDPR in the European Union has identified, they've gone in from a general policy approach. They've recognized the right to be informed, the right to access data by individuals, the right to rectification if there's a flaw or a mistaken statement there, the right to restrict processing, the right to portability so that if it encourages competition that an individual can move their data, and also the right to erasure or the right to be forgotten, so-called. From a policy perspective, did they get that right, Ms. Wu? Have they got it right, and are there gaps in what we've seen them attempt to accomplish?
Thank you, Mr. Congressman Lynch, for the question. Many of the principles in the GDPR are reflective of fair information principles. And in fact, some of them are reflected in the Fair Credit Reporting Act. Some of them were adopted in California with their consumer privacy law. The devil is always in the details. When you talk about principles-based regulation, you want to drill down to the details, but in general, GDPR has put in place a stronger framework than exists in the United States, and has served as a model, as you can see, for some states.
Thank you. Mr. Carpenter, What are your thoughts? You're trying to develop this uniform standard on APIs. Would your suggested structure embrace those rights that have been articulated in the GDPR?
Thank you, Chairman Lynch. So I think a couple things are at play. One, technical API standards defined by the industry will always be subservient to any regulatory or policy actions that are put in place. And so whatever the industry defines, if the CFPB or other regulators define principles or specifics, then standards will meet those obligations as needed. I think it's important to think a little bit about the complexity of the U.S. market as compared to the EU or some of the other countries that have gone with a strong regulatory model for open banking or data sharing. One, a lot of those countries have a single financial regulator. We have a myriad of them, a lot of times with overlapping jurisdiction in these areas. A lot of those countries also have the financial services industry is held by just a few banks. We have well over 10,000 financial institutions in this country. And so I think the U.S. is unique in its complexity. And so there will need to be a balance between what the regulators do as well as what the industry does. And so I can't comment specifically on exactly what regulators should do or where that dividing line is, but we typically look at open banking as a how and a what. The what is really up to regulators and policymakers. The how is this accomplished? How does data move from point A to point B? And that's what we think is best left to the industry.
Thank you. Ms. Cochran.
I think that the GDPR framework is extremely helpful in the sense of thinking through the elements that need to be decided in really creating robust consumer and small business control over their own data. But the exact policy balancing really depends on the particular use case that you're doing. So for instance, we've really focused on credit, which I think is one of the hardest cases, because while the existing credit information system, traditional credit bureaus often don't require consumer consent to access data, the new system under 1033 does. So that creates an opportunity to create a much more robust system where consumers have more control over what's happening. At the same time, you have to balance that against the need of creditors to be able to access representative historical data so that they can develop models that are fair and predictive and do a good job for both the customer and the lender. And so balancing both the individual rights and the public interests are complicated. So GDPR is really helpful because it starts to think through those questions, although I think often the balance may be different for particular use cases in particular situations.
Doesn't much depend on consent, meaningful, real consent?
Yes, that's one of the things that I didn't get much time to talk about in my main testimony, but a lot of our system today in the US does depend on notice and consent to data activities, but it's kind of a take or leave process. And what GDPR does is a much more robust thought process about how can consent be revoked, can data be deleted, other questions. And so thinking about consent is more than a one-time transaction. But we also know that there's a great deal of evidence that consumers are already overloaded by the decisions they're being asked to make, by the notices they're being asked to read. And so one of the things that I think GDPR is struggling with, and that would come up as the US looks at this, is how do you make some of those decisions simpler so that consumers can really focus on the critical things that they need to decide and strip away some of the surrounding things that may be more secondary, could be more consistent, and then make the decision more meaningful and more powerful, in addition to those rights.
Thank you. The chair now yields to the ranking member, the gentleman from Ohio, Mr. Davidson, for 5 minutes for his questions.
I thank the chairman. I think our witnesses appreciate not only your verbal testimony, but the written testimony as well, and the preparation you've done for this hearing. Mr. Smith, a November 2019 survey by the Clearinghouse found that 80% of financial app users were not aware that apps may use third parties to access consumer financial information. From your personal experience, can you speak to the progress that's been made within the fintech industry that would improve customers' awareness of how their financial data is being used?
Yes, thank you very much. So with respect to the issues surrounding consent and knowledge of consent, a lot of progress has been made. Finicity, for example, makes it very clear that Finicity is a services provider in the middle of the consented process between the consumer and the financial institution or financial services provider that holds their data. They see it, the FDX organization has also put in place a working group and has promoted standards, UI standards, that make it very clear how to use consent or how to apply consent in a best practices format. It also makes very clear the players that are involved in that. And then I would just say that Finicity, together with several others in the industry, both data holders and technology providers, have started implementing at pace dashboards that allow consumers to understand who is involved in the consent process.
Yeah, thank you for that, and just highlighting the user friendliness. Ms. Cochran, your testimony in particular highlighted the consumer friendly nature that is really so important. You know, a lot of times people will say in industry in particular, well, it's in our terms and conditions. And if you print it out, it's, 400 pages at 6-point font, and sure, you just acknowledged it. Could you elaborate on that and how we could do this? I'll come to you next, Mr. Carpenter, because some of the things you've both dealt with deal with how GDPR is being applied versus really our inaction in America on privacy.
So yes, there's some academic research that I think suggests that consumers would have to spend 25 days a year reading all of the disclosures that they get on digital data across all sectors, not just financial services, but I mean, it's really incredible. So clearly we need to get much crisper about and much more customer friendly about the disclosures that are being done to make them really effective just in time, adapted to digital formats. A lot of people are reading things over their phones and really thinking through those questions. At the same time, as I said before, we also need to think about how many questions are we asking consumers to answer in one shot? And do you divide those into maybe smaller chunks to give consumers more control as they think through their process and different questions at different times? So there's a real challenge ahead. The CFPB has disclosure authority that can be really helpful in this space. Consumer testing, obviously, is going to be hugely important. I think there are already some industry efforts that are moving in that direction. But we know that there's this broader question about overload that is really, it's one of the biggest challenges in this space, is to make that meaningful and manageable and quick in a way that's helpful to consumers.
Yeah, thank you. And I think you also touched on the fact that, some things just have to be off the table, because none of us want to use an interface that's just a relentless series of pop-up ads. It's a tactic. It's not actually real consent or choice for consumers. Mr. Carpenter, one concept I think is key to the discussion is the idea of data minimization, or the idea that companies should collect minimal data to provide the product or service. On the other hand, many businesses collect data that is not directly tied to providing the service. And of course, they want to use it maybe someday in the future, perhaps even for resale, who knows? There's no end to the amount of data that some companies want to collect. Mr. Smith, you talked about, you made that reference that, there are trade-offs, but I was really pleased that you concluded that, we're never, the Fourth Amendment's not for sale. Another bill that we're going to try to deal with in a bipartisan way. Could you touch on how to strike that balance and where regulators can help do that?
Yeah, thank you, Congressman Davidson. So I'd say, first of all, on data minimization, it's something that FDX is looking at in terms of defining, and really APIs, as opposed to screen scraping, provide far more consumer control over your data sharing. With screen scraping, you're sharing everything you can see. And with APIs, you do have the ability to potentially limit data that you share for a given purpose. We have internal use cases that are used really for certification on the back end to assure that the implementation of an FDX API is actually certifiable. The question is, what can we do on the consumer front end to possibly provide that? So that's an area that we are looking into. I will say, just to touch on your prior question as well, awareness is one of our 5 principles, consumer awareness. We're defining user experience, and per the other witness's testimony, we're looking at it both on the front end. What does the enrollment look like? How many screens does it take before a consumer just drops out? Right. Because there's too many questions, but then also through these dashboards. So it's not just a one-time awareness, but an ongoing awareness.
Thank you for that. And my time has expired. I yield.
The gentleman yields back. The chair now recognizes the gentleman from New York, Mr. Torres, for 5 minutes.
Thank you, Mr. Chair. I have a real concern that the biggest banks in opposing Section 1033 rulemaking are stifling competition and choice under the guise of consumer protection and cybersecurity. There are, to be sure, legitimate cybersecurity concerns surrounding the consumer authorized use of data, but it seems to me those concerns are best addressed not by allowing the big banks to hoard financial information for themselves, but by regulating data aggregators and by protecting consumers. I disagree with Mr. Carpenter's earlier statement that the standard should be left to the industry because the big banks are not disinterested arbiters of what is best for consumers. The banks do have a vested interest in maintaining their oligopoly on consumer information. So my first question is to Ms. Wu and Ms. Cochran. Is it fair to say that the big banks have a conflict of interest and therefore cannot be trusted to make disinterested determinations about what data to share, when to share it, and with whom to share it?
Thank you for the question, Representative. Certainly, consumer advocates are very concerned about ensuring that consumers do have the ability to share the data when they have meaningful opportunity to consent. One of the things that banks early on used as a tactic to try to prevent data sharing is to tell consumers, if you share this data via screen scraping and there's some sort of unauthorized use, you will be on the hook, which we thought was just terrible. I mean, the last person that should suffer a loss if there's some sort of data breach or unauthorized access is the consumer themselves. And we thought Regulation E doesn't allow for that. And fortunately, the CFPB in a recent FAQ took that position as well. It's the consumer, not the consumer, who's going to suffer the loss. So we do think that 1033 rulemaking needs to go forward. And we are encouraged that there's been more cooperation, but ultimately I think there's need to be some regulatory teeth, especially if we're going to get rid of screen scraping, because we can't get rid of screen scraping until we have the ability of consumers at all banks to share the data. And that's not going to happen until you have these agreements with all institutions.
I would just add a couple of thoughts. As I said in my main testimony, there are competitive tensions all over this market, both banks, non-banks, and they intersect in very complicated ways. I think it's one of the reasons why it's so important for the regulators to set certain parameters to settle certain questions so that industry can focus on then implementing in an efficient way that actually benefits everyone once those decisions are made. The other thing that I think is really important here is that the interagency coordination that I talked about, because concerns about liability are legitimate open questions in this marketplace that affect everyone. And getting better answers to those questions and getting better answers to third-party service obligations, for instance, intersect with competitive interests. So if we can settle the regulatory questions, that kind of decouples these dynamics that can feed on each other in ways that tend to slow the process of the overall system and reduce the benefits for innovation and competition that 1033, potentially offers.
Thank you. And I certainly agree that there should be regulation. As I said, there are legitimate concerns about cybersecurity, and there's a legitimate concern that data regulators are largely unregulated and unsupervised. I guess my question is for Mr. Smith. I'm curious to know your obligations as a data aggregator. Do you have an obligation to provide accurate data and to correct inaccuracies and errors in data? Do you have a legal obligation to do so?
Well, so as an aggregator, we also maintain a CRA status and are regulated under the FICRA. We also have signed a number of bilateral agreements with leading financial institutions that require us to maintain compliance to certain aspects of GLBA, and we maintain compliance to both state and federal consumer privacy regs today, and also maintain compliance to GLBA. So that's the scope of the regulatory framework that we fall under.
And I have a question for Mr. Carpenter. I'm concerned about screen scrapping because it involves the use of login credentials. What's the timeline, in your opinion, for a full transition to API?
It's a great question. I wish I had a clear answer to give to you. I think you have to think about, and Ms. Cochran talked about this a little bit, Ms. Wu did as well, there is a long tail in the US. And so while the biggest financial institutions who usually invest in their own technology stack are quickly able to move to APIs, a lot of the community financial institutions or minority-owned financial institutions are usually using a technology core provider. And so they're waiting for that core provider to give API access or to essentially level the playing field across all the financial institutions. So I would just say, bringing the core providers in, and we have several that are members of FDX, to ensure that there's not a gap between the large and the small will help that timeline accomplish. But I think with any technology transition, we often talk about the chip card, the mag stripe to chip card transition. There were a lot of different waypoints along the way that had to be accomplished before you could declare success.
My time has expired. Thank you.
The gentleman from New York yields back. The chair now recognizes the gentleman from Missouri, Mr. Lukenmeyer, for 5 minutes for his question.
Thank you, Mr. Chairman, and thank you all of our witnesses today. Interesting discussion we're having here. Whenever I discuss screen scraping with my constituents and explain to them what it is, they are aghast. They are absolutely horrified that when they give an okay to a third party to their utility company to direct draft off their bank account, they wind up with a third party having access to their account. They are absolutely horrified that this is happening. So to me, why do we allow that? Why do we not have a separate agreement that says if you're going to be able to screen scrape and take that information and sell it, that the individual has to have a separate agreement with a different company, or with a company that's going to have a separate agreement with them that allows them to do that, and then pay them for that information? Why is that not a viable option, Mr. Carpenter?
Thank you, Congressman Lukemeyer. So I think, one, it's helpful to think about the context of screen scraping. It's an old technology. It's not a perfect technology. It has a lot of issues with it. It's also what has delivered the innovation that we have today in the competitive financial services market. And I would argue that without the ability to at least a consumer to access and share their own data via screen scraping, again, while not perfect, we would not have had the explosion in competition in the financial services industry. So
yeah, but Mr. Carpenter, let's be honest here. This is all done without the consumer's knowledge. Most of your consumers, I will guarantee you, Mr. Smith, you made a comment a while ago about 84% of the people didn't know what was going on, or they didn't approve of it, or had access to their information.
Yeah, I think that was referring to a TCH survey from 2 years ago.
But most people don't approve of what you're doing. They don't approve of screen scraping. So we're sitting here making the assumption that everybody thinks it's okay. I'm telling you, people don't believe it's okay. And therefore, we need to take a different perspective on this and say, whoa, okay, the first way you protect people's privacy and their information is to be honest with them up front and say, this is what's happening with your information and how people are accessing it unknowns to you. We're approaching this from the wrong angle, I think. If people want to allow their accounts to be screen scraped, that's fine. That's an individual decision. They want to be able to have other people, other companies access to it so they can provide them with other options and other services. That's fine. But most people do not know what's going on and would be very reluctant to sign a form that says it's okay to do that. And I think, so my question is, why can't we do that? Why can't we have the company be honest with them up front and sign a separate, completely different form? Yeah, I understand, Ms. Cochran. We're going to have another screen you have to go through and sign something off. But this should be in bright red letters, a whole new screen that says, when you sign this agreement, you're going to give access to the screen scrapers of the world to go with this. And this has to be something completely different than having a third party be able to have access to your account to make payments for you.
And Congressman, that's exactly what we're doing as fast as we possibly can to move to an API realm where instead of giving your login credentials, you're actually being taken to your financial data provider or financial institution. You're logging in, you're permissioning your data there at your bank on your mobile app. You're then being handed back with a token or a key so that an API does completely circumvent the sharing of login credentials. So the industry is rapidly moving in that direction. As I mentioned, 22 million consumers have currently been transitioned to the FDX API. It's just a matter of, it does take time. You can't flip that switch overnight and cut off access to consumer data sharing that they have. And I think we're also working.
Whoa, time out, Mr. Carpenter.
Yes, sir.
You missed my whole point by your last comment. People are unaware that this is going on. Why are you allowing it to continue? Shouldn't we, as Congress or our CFPB as a regulator, say, whoa, people are not aware that this is going on. They should be told. There should be options presented to them. Why can't that be done right now? Why is it allowing to be continued to go on? Why is it allowing to continue on whenever we know that people don't know what's going on?
And I would just,
if I may, this is one where we completely agree. You and I are on the same page. We think that this sort of mice-type consent is not acceptable. We need meaningful, informed, separate dashboard, separate web page consent, and not just a yes or no, but how much information to share and for how long. I understand the concern about information overload. It's something we're worried about too. And how you design the consent is very important, and that's something that FDX and others are working on so that it's easy. But yeah, a yes/no decision would be easy, would prevent overload, but it wouldn't maximize the control. And we think the consumer should have maximum control over their own data.
I see my time's expired, Mr. Chairman. I'll yield back. Thank you.
Gentleman yields back. The chair is very pleased to welcome the chairwoman of the full committee, the gentlelady from California, Ms. Waters, for 5 minutes for her questions.
Thank you so very much, Mr. Lynch. I certainly appreciate this, this hearing. It's very important, and it seems as if I'm agreeing with Lukemeyer for the first time since we have served on this committee together.
Isn't that an overwhelming feeling, Madam Chair?
Well, I want to make sure, and this may have been discussed before I came in, but I want to know about opt-out as opposed to opt-in. I get, from, the people I do business with, whatever, something in small writing on page 15 somewhere that says, if you want to opt out, you've got to let us know. And so most people don't pay attention to that. They don't even know what is meant by it. And so if you don't opt out, your information is shared with a third party. Third party shares the information with somebody else shares the information. And then you get all these solicitations and people who are not only soliciting you for their products, we don't know anything about those firms and what protections we have, et cetera. So this is very simple to me. And Mr. Lukemeyer asked, why don't we just change it? Why don't we just make sure the consumer knows? He talked about it a little bit differently, but my question is very simple. Why don't we just change the law or make a law that says you can't simply offer to opt out on page 31, and if you don't do it, your information is going to be shared. Mr. Carpenter?
yes, ma'am. Madam Chairwoman, thank you for the question. I want to be very clear up front. I am not in any way sticking up for screen scraping in its current manner. Our entire organization's mission is to move to a new API standard. In terms of your question, everything that happens through consumer permission data sharing is directed. It is that opt-in, as you say, directed by the consumer. They're the one that download the app to start with. They're the one that go to their financial institution to permission their data. So none of what we're doing with FDX is taking a consumer's data without permission or consent.
Ms. Cochran?
Yes, I think this is an incredibly important issue, and it cuts across 1033, Graham, Leach, Bliley, and the Fair Credit Reporting Act. Right now, we have federal laws that don't require consent at all. They just set permissible purposes and say companies can use within those bounds. We have laws that rely on opt-out consent, which means the data flows unless the consumer says no. And now with 1033, we have a regime where the consumer has to say yes to turn it on. So we have all three in our current system. We know consumers are overloaded with the choices they're making. And so the balance between both how do we do consent well, where consumers really understand and are making the decisions they intend to make, And how do we, in some cases, maybe define the permissible purposes so they don't have to decide everything on a company by company or product by product base. That's why this is so complicated, and it really requires looking more broadly, even beyond the 1033, to get to the answers to some of these questions.
And what is your recommendation?
There's a lot of evidence that opt-out consent is very sticky, that consumers don't tend to see it. They may not be reading those regimes. And so I think that one in the middle is a particularly tricky category. We know in GDPR and some other jurisdictions, people are starting to look harder at permissible purpose regulations so that consumers don't have to decide everything, or that there are gradations and tiers to how many things that are being asked to decide how quickly in one setting. And I think closer looking at both of those options is potentially really helpful to
I want to
make
be,
this
I
more
want to be
rational.
very clear that on the opt-out opportunity, if you do nothing, that means that you opted in. Is that right?
Right.
Something's wrong with that. Thank you. I yield back the balance of my time.
Madam Chair, I'm going to yield to Mr. Carrillo to ask him to offer his observations on this.
Thank you very
Carrillo, you're
much.
recognized.
Thank you very much, Chair Lynch, and thank you for the question, Chair Waters. I think that permissible purpose regulation is necessary at this point, and we need to go beyond the notice and consent paradigm. It is possible within notice and consent laws to allow for click-wrap contracts, as the National Consumer Law Center has noted, that give companies the ability to harvest data based on the agreement, but data that is far more than what was intended by the consumer. So the agreement between the consumer and a company is not the appropriate side of regulation. We need to establish a longer list of how companies can use data and to what end. There are still tricky questions as to intent, but it's a better frame to look at this from a broader perspective of public policy rather than identifying what consumers understand or not at the point of sale or point of agreement. Thank you.
I thank the gentleman. The chair now recognizes the gentlewoman from Georgia, Ms. Williams, who is also the vice chair of the Subcommittee on Oversight and Investigation. She is now recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for holding this hearing today for this important task force. Anyone who has followed my work in Congress knows that closing the racial wealth gap, where my home of Atlanta unfortunately is the worst in the nation, is a goal that I infuse into all of my policy work, especially my work here on the Financial Services Committee. In Congress, we have to be sure that financial innovation proceeds in a way that doesn't just deliver benefits to a few, but to all, especially those most marginalized. Today, I'd like to focus on how we ensure personal consumer data is not used to reinforce racial and other biases. The discussions that we have here and the policy that we pursue will determine the level of progress that we make toward building an economy that is inclusive and fair for all. Ms. Wu, in your testimony, you mentioned that we need to be looking out for and preventing disparate impacts when it comes to data used for credit purposes. Could you elaborate on what best practices Congress can employ to make sure that we're picking up on any broad patterns of disparate impact? How can Congress be sure we're addressing any issues through legislation as needed and making sure that the CFPB and other agencies are writing appropriate and timely rules of the road?
Thank you for the question, Congresswoman Williams. Certainly, whenever big data sets are used, whether it's new data like cash flow information or old-fashioned data like credit reports, one of the things that you really want to look for is racial disparities and disparate impact. So we know as a baseline that credit reports and credit scores exhibit huge racial disparities. Cash flow information and the work by FinRegLab shows that it may be more promising as a source of information, but it's still going to show racial disparities. Why? For a number of reasons. It still reflects fundamental underlying racial disparities in economics in our society. And second of all, overdrafts. Cash flow information will never truly be able to benefit consumers of color until we get rid of overdraft abuses, because that's one of the key things that they look for in cash flows. And we know overdrafts hit minority consumers a lot harder. We got to deal with the overdraft abuses. with respect to big data sets and artificial intelligence and machine learning, one of the things we've seen is that they are not free of racial disparities. They reflect back what exists. If you take a data set that inherently has racial disparities and you have the AI or machine learning model learn from it, it's just going to replicate it. And the problem is people think, oh, AI machine learning, there's no bias, but it is. It's all a reflection of the underlying data that's a reflection of the inequalities in our society. And so we need to be cognizant of that. We need to be aware of that. We need to, the unequal position of African Americans and Latinx consumers in this society was built from decades and centuries of discrimination intentionally. And we're not going to deal with those disparities until we intentionally try to address them consciously. If you just say, let's treat everyone equal, that's not equity, and that's not going to do it.
So, Ms. Wu, you just mentioned that Black consumers are desperately impacted by bank overdraft practices, and that we should keep this in mind when related to consumer data, to who consumer data is employed. So how could greater use of no-fee accounts address the underlying disparity informing the data going forward? Can you tell us the importance of simultaneously addressing concerns with the data use and the real-life disparities that inform the data being used?
Certainly, there have been a lot of efforts to provide bank accounts for folks who've struggled with overdrafts that don't impose overdrafts and overdraft fees, that don't allow people to overdraft with their debit cards, which is a huge problem, that don't reorder transactions. And efforts by organizations to promote banking are very helpful. And you can't get cash flow bank account information if you don't even have a bank account. And we know there's also disparities on who has a bank account. And we know that lots of consumers, low income and minority consumers, are driven out of the banking system by overdraft abuses. So yes, efforts to get unbanked consumers into bank accounts that are low fee and safe are really important. But what's even more important is congressional action to just tamp down on those overdraft abuses and make sure that they don't hit all consumers, not just the ones who are able to benefit from no fee and safe bank accounts.
Thank you, Ms. Wu. And I am out of time, Mr. Chairman. So I do have another question around technology and broadband access, but I will submit that for the record and hope that one of our esteemed panelists can get us some answers on that as we continue to move forward in this work. Thank you, and I yield back.
I thank the gentlelady and we welcome her question. The chair now recognizes the gentleman from Wisconsin, Mr. Stile, for 5 minutes for his questions.
Thank you very much, Chairman. I'd like to dive in, Mr. Carpenter, if I can, with you. In your testimony, you talked about the what and the how of open banking. I thought it was well said. The what being the question of which data fields are shared and under what agreements or restrictions, and the how more of a technological question. I think another really appropriate question for us, and I'd love to have you speak to it, is what is the appropriate role of the federal government in helping to address those two questions that you pose?
It's a good question. I wish that I had the perfect dividing line for you. I tried to set it up. I think what has happened in the U.S. is many will say, oh, the U.S. is so behind in open banking. The truth is we're actually in front. If you look at the number of consumers who have access to their data, the ability to use it in innovative fintech services, we're actually leading the world in that regard. And so I would argue that the CFPB and other regulators have actually taken an appropriate time to watch the industry mature in this area. That said, where there are friction points, the federal government may need to step in to decide some of these issues. So industry standards can do a lot, but we're not a silver bullet. We cannot answer every single sticky policy question. And so I think where the government might see friction between the industry or the inability to come to a decision on, say, the scope of data or the like, it may be a role for the federal government to step in.
Thank you. I'd like to follow with you, Mr. Smith, to offer your thoughts on the same thing, hearing kind of his take. Could you give us a little thought as to what the appropriate role of the federal government is in this?
Yeah, I think when you take a look at some of the conflicting aspects of this, as I spoke to in my oral testimony, you often run into situations where under regulation, financial institutions are, and rightly so, very concerned and very focused on safety and soundness. Safety and soundness gives way to data security, data privacy, gives way to limitations on the types of data that might be accessible. So when you look at right to access, right, regulation would be helpful, clarity would be helpful to determine, types of data and scope of data that can be accessed for particular use cases, for example. So these are the kinds of things that, as a data aggregator, and I would just say, we've been leading the industry and signing bilateral agreements with financial institutions. By the end of this year, we'll have greater than 60% of our data, 60% of the data flowing through our access pipes integrations through API integrations, right, that use OAuth as an authentication methodology and do not collect credentials. And we further will have in the pipeline another 20% of the market coverage in integration development. And so these are some of the key issues that we deal with. And
let me build on that a little bit, because I think in your written testimony you comment on some other countries and their open banking policies. I want to get back to Mr. Carpenter as well on the same question. Looking at what other governments have done as far as government intervention in the private market in this space, what lessons learned can we have about the appropriate role of government regulation in this space?
Yeah, I think Mr. Carpenter's comment, the U.S. has certainly been leading from an innovation perspective and has had more of a wait and see attitude from a regulatory perspective, where other countries have been a bit more aggressive or proactive from a regulatory perspective.
In knowing that they've been more aggressive, more proactive, your term, what do you think the lesson learned is from that? Do you think that?
Yeah, so I think there is benefit in understanding what the use case and the value proposition is to consumers, and forming regulation around ensuring that consumers are not harmed in any way, and that the value proposition associated with open access to data is maintained.
Okay, let me jump back to you, Mr. Carpenter, on the same topic. What lessons learned do you see from government intervention, in particular in foreign countries?
I would argue that the lesson learned is that you can't really go with all one approach or the other. There really does probably need to be a hybrid approach. When you have an entirely regulatory dictated system, you end up with compliance versus actually meeting the needs of the market. And so what standards are able to do is actually follow the consumer. Where's the demand? Where does the market actually need definition and standardization? It doesn't mean that there may not be room for principles-based regulation or government action that solves some tough questions. So I would argue that what we've seen is that you probably do need a little bit of a mix of everything.
Thank you very much. I apologize for the time. We couldn't get to all the witnesses. I yield back.
The gentleman yields back. Well, together with the ranking member, the gentleman from Ohio, Mr. Davidson, I'd like to thank our witnesses for their testimony today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. And I ask our witnesses to please respond as promptly as you are able. I think we might expect a question from Ms. Williams. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. I remind members that written questions and materials for the record should be submitted to the email address provided to your offices. This hearing is now adjourned. Thank you.